The goods which will be produced later, it may be after 6 months or 1 year, the goods are called as future goods. The buyer cannot terminate the contract in the concept of sale, but in the concept of hire purchase, the buyer can cancel the contract if he doesn't want to continue. The item what we are selling here, it should be a movable commodity, movable product, movable goods. Warm welcome to 4th Sem BCom student. The subject we're discussing, business regulatory framework. In our present session, we are going to discuss about Sale of Goods Act 1930, which was separated from Indian Contract Act of 1872. Earlier, the sale of goods concept was included in Indian Contract Act itself, but later on, it was separated in the year 1930 and it came into existence, means came into force on 1st July 1930. So, Sale of Goods Act was introduced and came to force on 1st July 1930. I am Professor Rajesh L.R. from Department of Commerce and Management, Vidhyaashram, First Grade College, Temple of Excellence. The agenda for today's concept, what we have here for the Sale of Goods Act 1930, first we are going to learn Introduction to Contract of Sale of Goods and the meaning of goods as per Section 2, Subclause 7 of SGA 1930, Sale of Goods Act 1930, and types of goods. We are going to discuss the difference between the sale and agreement of sale, difference between sale and bailment, sale and contract of work and labor, effect of perishing of goods, condition and warranties in the concept of sale. We are going to discuss here, and from examination point of view, out of these three concepts, any one question will be there for 10 marks. Go through that properly and understand and explain that. The first concept, as I said, that one, Introduction of Sale of Goods Act 1930. It is one of the special type of contract. Initially, it was the sale of goods was the part of the Indian Contract Act 1872, but later on, a separate Sale of Goods Act was passed in 1930. It came into force on 1st July 1930. It extends to whole India excluding Jammu and Kashmir. So, excluding Jammu and Kashmir, all other states comes under the concept of Sale of Goods Act 1930. Contract of Sale of Goods. What do you mean by that one? As per Section 4, Subclause 1 of the Sale of Goods Act 1930, contract of sale of goods is a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a price, where I'm going to transfer all the rights of the property to the person who's going to buy goods from me. This is a concept what we have as per Sale of Goods Act 1930. What are the essential elements? There must be two parties, buyer and the seller. The subject matter of the contract must be goods. Here, the subject matter means the sale of goods means it should be only the goods. Other than goods will not be considered under this concept. A price in money should be paid or promised. In the Sale of Goods Act 1930, it says that when the goods are transferred from the seller to the buyer duty is to pay the price for the goods, whatever he has purchased from the seller, either immediately or he has to promise to pay that amount within certain duration of time. So, this is the agreement will be between the seller and the buyer. A transfer of property in goods from seller to the buyer must take place. Means it is not only in the records or only in the words, it should be there, I'm going to sell the goods. The party will say, I'll buy the goods. Transaction or the event has not taken place here, where I'm saying that when I'm just selling the goods to the buyer who is going to buy the goods from us, and is going to pay the price for that one. This concept has to take place. If it has not taken place, only it is in the words or in the paper where it has written, sold or received without any event has taken place. So then it cannot be considered as a sale under Sale of Goods Act 1930. It must be absolute or conditional. They're saying that one, the sale of goods, what we are making here to the buyer, either it should be the goods has been sold and immediately the amount has been received. That is the absolute without any conditions here. Or certain things are there. The seller wants to sell the goods where the buyer wants to buy the goods here. The seller puts certain condition that the goods will be sold only for cash. The goods will be sold on credit terms only for 2 days. Or the goods will be delivered after receiving the cash. Like this, certain conditions may be laid down by the seller here. So the sale of goods, either it may be absolute without any conditions or with certain conditions. All other essentials of valid contract, what we have discussed in our Indian Contract Act 1872, that will be considered in the Sale of Goods Act. Goods. What do you mean by goods here? It means every kind of movable property, like this pen is, I can move this from one place to other place. Any goods which it is a mobile property other than actionable claim and money, and includes stock and shades, growing crops, grass, things attached to or forming part of the land which are agreed to served before sale or under the contract of sale. The item what we are selling here, it should be a movable commodity, movable product, movable goods. Even it includes stock and shades, growing crops, grass, and even forming part of the land where it is attached, certain concept here like coconut trees, mango, growing a mango fruits or any fruits and vegetables like this. Those concepts will be considered as a goods here. If we are saying that one, we have sold a land, can it be considered under Sale of Goods Act? No, it is immovable property. So for that reason, they are saying that one here, only the movable concept are to be considered, not immovable. Actionable claim means what a person cannot make present use of or enjoy, but can recover it by means of suit or an action. When I have given a debt to a person, and at the time of giving a debt, we have taken the property, means they have pledged the property and they have taken the loan here. When the person failed to make the payment of the debt amount, so those property can be made as an auction and I can claim the amount and I can get the benefit from that. If we have that concept here, that can be considered here sold as a goods, although it can be assigned under the provisions of the Transfer of Property Act 1882. So as per the Transfer of Property Act 1882, this is considered as goods only. How many types of goods we have? So existing goods, future goods, contingent goods. Existing goods, again we have specific, ascertained goods, unascertained goods. What are those things? Existing goods, it means such goods which are in existence at the time of contract of sale. Means the goods is existed here. This is called existing goods, where I'm going to say that one, I have 1,000 pens with me. It will be sold at a price of 15 rupees each if they are going to pay in cash. If they require the same product on credit terms, it will be sold for 19 rupees and the credit term is only for 1 week. And for the people who are going to pay cash and buy this product, it is 15 and a cash discount and trade discount of each 5% will be given for the buyer who is going to buy the goods with us. So this is existing and the sale concept what we are going to make with the buyer. Specific or ascertained goods, it means identified and agreed upon at the time the contract of sale has been made. So sometimes the buyer is going to identify certain goods and he says that when I'm going to buy this product from you after converting into a finished product. Now we're going to have a contract between us. The goods, whatever you're going to produce, that has to be sold to us, and the goods has to be produced according to the requirement, whatever we have given or specified in the purchase order or the agreement, whatever you're going to have it. Generic or unascertained goods, it means the goods which are not specifically identified but are identified by description. Some of the goods are there which cannot be identified properly, but it can be ascertained with certain things like with the description. So we can say that one, okay, this product can be bought like this. The goods are called as unascertained future. It means the goods are to be manufactured or produced or acquired by the seller after making the contract of sale. So the goods which will be produced later, it may be after 6 months or 1 year, the goods are called as future goods. Contingent goods, it means the goods, the acquisition of which by the seller depends upon a contingency which may or may not happen. So he doesn't know that one. The goods which we are producing can be sold or not, even though it's going to produce certain times. It may be sold or it may not be sold in the course of action. Now, let us enter into the differences between the sale and agreement of sale. What is sale? It is an executed contract. Agreements, it is an executory contract where we are agreeing to sell the product. But here, the event has taken place. Here, the event has not taken place. Property and goods are transferred from seller to buyer when the contract is made. So immediately I'm going to transfer all the rights of the property to the buyer. Transfer of property and goods takes place at some future date. Here, when we are making agreement, only after completion of all the terms and conditions of the agreement, the transfer of rights will be made to the buyer. Until that one, the rights will be with the seller only. Seller cannot resell the goods as the property is with the buyer. In sale concept, the seller cannot resell the goods, whatever it has been sold to the buyer, because all the rights has been transferred, even the goods has been transferred from the seller to the buyer. But in case of a seller can further resell the goods as a property and good remains with the seller himself. So the goods as well as the rights will be with the seller itself. Even if he wants, he can resell that one in case the buyer makes any breach of contract. Next, fourth point what we have, the risk passes to the buyer as he becomes the owner of the goods or property. The risk from the seller is immediately transferred to the shoulder of buyer, and the entire risk will be on the shoulder of buyer because the rights of the property has been transferred. The risk of the property will be in the hands of seller only because still the property or the rights has been not transferred. Breach on part of buyer, seller can sue for the price and damages both. In case if the buyer fails to make the payment, the seller has the right to claim the damages and the price what he has to make the payment, and he cannot claim the goods, or he can't take the goods whatever he has given to the buyer. Breach on part of buyer, seller can sue for damages only and not for the price. See, here for both price and here he can sue for the price and damages, but here only for damages and not for the price because the goods has been not transferred. The rights has been not transferred here, only for the damage what it has happened. For that he can claim the benefit from through the court of law. Sale is contract plus conveyance. Here selling the goods means contract plus conveyance. It is pure simple agreement. It is perfect and a simple agreement where the goods will be sold to you on certain date. The amount has to be paid. In the initial down payment should be made, and later when we are going to deliver the goods, remaining balance amount should be paid, then only the goods will be delivered. Like this we are going to have. In this, if the goods are destroyed, then loss will be borne by the buyer. In case the goods has been destroyed due to fire, the risk has to be borne by the buyer. But in this case, it should be borne by the seller. That's it. This was a simple differences where it comes for you people. For 10 marks question, analyze and write it properly. The next we have here, sale and bailment. Property in goods is transferred from the seller to the buyer. There is only transfer of possession of goods from bailer to bailee. Here, transfer of goods and property, both it will be made. Only the possession of the goods will be given, rights will be given to the buyer, not the entire rights. Consideration is the price here, the amount what they're going to pay for the purchase of goods by the buyer. Here, consideration may be gratuitous or non. It may be both in terms of money or money's worth. Or sometimes we're not going to receive the money. Buyer may use the goods in any way he likes. So here the buyer who has bought the goods from us, according to his requirement, he can use the product. But in the bailment, they cannot use, only according to the direction of the seller, the goods has to be used. Next we have here, contract for work and labor. Property in goods is transferred from the seller to the buyer. It is a contract for performing some work and not transferring the property in goods. See, what is the difference we have here? Sale and contract for work. Here, in the sale, the rights of the goods and the property will be transferred to the buyer. But here, it is a contract for performing some work and not transferring the rights of the goods here. It involves delivery of goods. So, we are going to deliver the goods to the buyer. In this case, the exercise of skill and labor in rendering some work means we are giving a job work for the people where they're going to use their skill and they're going to convert the raw material into finished goods, or for example, interior decoration, what they're going to make. We are giving a task to them and we are giving a job to them where they're going to work. That's it. They're not going to deliver the people here. Next, we have sale and hire purchase agreement. See, in this concept, the rights of the property will be transferred immediately at the time of sale. Here, only at the payment of last payment or last installment, the rights of the goods will be transferred. It is position of buyer is that owner. It will be called as the owner here, but here the bailee, after making the last payment, is going to become the owner. Buyer cannot terminate the contract. Here, the buyer cannot terminate the contract in the concept of sale, but in the concept of hire purchase, the buyer can cancel the contract if he doesn't want to continue. Seller takes the risk of any loss resulting from the buyer's insolvency. In case if the buyer is going to become insolvent, the seller takes the responsibility. The owner takes no such risk for the fail in the installment. He has the right to take back the goods. Here, in this case, if anything happens, then the owner of the property will never take the risk here. The person for whom it has been given the goods will be taken back, and even if it is possible, the amount will be collected if it is possible, or else it will be not collected. Next, effect of perishing of goods. Goods perishing before making a contract. Where in a contract of sale of specific goods, the goods without the knowledge of the seller have perished at the time of making the contract is void. See here, when we are selling the perishable goods, at that time, we have to verify the goods it is in a good condition, or where it is going to spoiled, or whether it is damaged or it is exhausted. So after seeing those things, we have to make the contract here, or else if the goods is not in the good condition, the contract made will be called as void. Goods perishing after agreement to sell. When the goods has got damaged after the agreement of sale, where there is an agreement to sell specific goods and subsequently the goods without any fault of any party perish before the risk passes to the buyer, the agreement is thereby avoided. The provision applies only to sale of specific goods. Only for the specific goods, this concept is accepted, where the contract made between the seller and the buyer will be void because the goods has been damaged. Only for the specific goods. For all other types of goods, this concept is not adopted. Pricing. Price is a money consideration for the sale of goods. The price has to be received for the products or the goods what we are transferring with the rights to the buyer. The buyer duty is to pay the amount of price for the product or commodity or goods whatever he has purchased from us. At the time of contract by the parties themselves or may be left to the determined by the course of dealings between the parties, may be left to the fixed in some way stipulated in the contract, may be left to be fixed by some third party. Here, either the buyer and the seller can decide immediately, or in the agreement, while making the agreement, they can decide what is the amount of price is to be collected or paid. After discussion, they're going to have, or in some cases, a third party enters and he makes this the amount can be paid for the sale, what a person wants to sell the goods, or to the buyer, you can buy the product at this price and this is the actual price for this commodity or the goods. Conditions what we have here. If the stipulation forms the very basis of the contract or is essential to the main purpose of the contract, it's a condition. That's saying that one, how the contract or the agreement should be performed between the two parties, then we're going to say that one. Like for example, the seller says that one 10% down payment should be made. 4 or 3 installments will be given to you. After making the 3 installments payment, the rights will be transferred. Like this, you must say that one. This is a condition. Or you may say that one, after clearing all this part here, I'm going to deliver the goods. So I'll give the 4 installment concept. One is down payment, first installment, second installment, third installment. Then at the time of delivery of the goods, you can make the entire payment. So both the concept are conditional concept what we have here, and it says that one, as per the specification what you are given, the products will be produced and sold. In case if it doesn't matches to the specification, the goods can be sent back to the seller because it is not equal to the sample or the product whatever they have displayed or shown with the examples and the experience of the goods with the persons. Like this, if they have made any different concepts here, with the help of the conditions, the goods can be returned back. And in case if the buyer delays in the payment, the seller has the right to get back the goods as per the conditions. Like this, we have certain conditions which will be made between the buyer and the seller. Warranty. If the stipulation is collateral to the main purpose of the contract, that is subsidiary promise, it is a warranty. So, here one more condition and warranty. The condition was different and the warranty is totally different. Additional point for or sub point for the condition here. If goods are destroyed or if goods are got damaged in the transit or after unloading the goods at the buyer place, the seller has to replace the goods. There's a warranty, and if before it reaches to the godown of the buyer, or you can say that one, if there is any default in the production part here, the product has to be exchanged or the amount should be reduced in the payment whatever we're going to make. This is a warranty. Thus, if the seller does not fulfill a warranty, the buyer must accept the goods and claim the damages. If the seller feels that one, I'll not provide the warranty concept for this one. So then the buyer has all the rights. He can claim the goods, and in the same time, he can claim the damages, whatever it has happened to him. Warranty stipulation condition as to time of payment or not to be deemed condition unless such an intention appears from the contract. So here, the buyer and the seller are making a contract between them. At the time of delivery, the amount should be paid in full, and a cash discount and rent discount will be given. And in that one, in some cases, the buyer may say that one, after verifying everything, I'm going to make the payment. I'm going to make the payment at the time of delivery of goods. It is perfect. But let me verify whether the condition of the goods are proper, or if it is in the good condition, I'll make the payment immediately. Is going to convey the message to the seller. Whether any other stipulation as to time of delivery, essential contract of not, depends on the terms of the contract. Here, one more concept what we have here, the time period for the delivery will be mentioned by the buyer at what time they have to deliver, and it will be better for them to receive and identify or verify the goods, because at that time they will be free, or they may be able to verify immediately and make the payment, or else the payment will be delayed here. Waiver by the buyer. The buyer may waive a condition. Once the buyer waives a condition, he cannot insist on its fulfillment. See, when the concept has been reduced, like I have laid down 10 points, the buyer has said that one, 2 points are not agree here. So then when he has cancelled the 2 conditions, after the fulfillment, he cannot get back and say that one, I want to continue those points. Compulsory treatment by buyer, where the contract is indivisible and the buyer has accepted the goods, a part thereof, the breach of condition can only be treated as breach of warranty. Thus, the buyer cannot terminate the contract but can only claim damage from the seller. If anything happens here, the seller has made a breach of contract between the buyer can claim the damages only. He cannot claim other than the damages. In the upcoming session, we are going to discuss implied warranties, conditions, caveat emptor, passing of property or transfer of ownership as per Section 18 to Section 20 as per SGA 1930. Namaste to all 4th Sem BCom students. In today's session, we have started the concept of Sale of Goods Act 1930, which is very important for your examination point of view. Go through that one. Thank you to all once again.